United Nations in New York on devolution of judicial powers to autonomous regions. Just a few words, a welcome, of course, to all our panelists and to all the participants. Some may join us later. In any case, this seminar will be bilingual, will take place both in English and French, so don't be surprised if I switch from one to another language. And you may choose actually the language that you listen to by switching either to English or French in the interpretation mode in your Zoom activities. And we anticipate some interesting work by the interpreters, so we thank them in advance. Before actually starting to give the floor to the panelists to talk about various experiences of autonomous regions from the point of view of devolution of judicial powers, let me give you some background or some introduction into this topic. So once again, I wish to thank the Permanent Mission of Morocco for initiating this seminar. Obviously, we would have preferred to be sitting with you in person, but as the pandemic has decided, and despite our efforts, we thought that instead of wasting more time, we would prefer to do this virtually. So thank you for you and again the eminent experts, professors who joined us to share their experience and expertise on various autonomous regions in the world. So let me first situate this seminar in its geopolitical and historical context. You may remember that on the 11th of April 2007, the Kingdom of Morocco presented to the UN Secretary General its initiative for negotiating an autonomy statute for the Sahara region in order to break the stalemate in negotiations on the regional dispute about Sahara. The UN Security Council, in successive 13 resolutions, qualified this initiative as, I quote, serious and credible. And it recalled, again, I quote, its endorsement of the recommendation that realism and the spirit of compromise by the parties are essential to achieve progress in negotiations. And it's called upon neighboring states, again, quote, to strengthen their involvement to end the current impasse and to achieve progress towards a political solution. With the aim of promoting discussion on aspects of this proposal, since 2009, Morocco initiated several international academic seminars in various locations, Dakhla, Geneva, New York, on various aspects of regimes of territorial autonomy, comparing achievements on several continents with the Moroccan initiative. And these comparative studies included the cases of Aceh, Andalusia, the Azores and Madeira, Bangsamoro in the Philippines, the Caribbean island states, Catalonia, Greenland, the Indian Northeast, the Iraqi Kurdistan, the Italian autonomous regions, Mexican states, New Caledonia, Newfoundland in Canada, Nicaragua's Atlantic coast, Northern Ireland, Nunavut in Canada, Puerto Rico, Quebec, the Spanish provinces, South Tyrol, Vojvodina, Wallonia, Zanzibar, etc. Those studies have been published by Morocco and are available on a dedicated website, www.morocco.org. Academic Autonomy Network, in one word, .com. Now, today's seminar will offer a new opportunity to study the lessons learned from experiences of devolution of judicial powers in the framework of systems of territorial or regional autonomy in several regions, as well as to compare them with the provisions offered by the Moroccan initiative. Indeed, regarding judicial powers, this initiative includes several provisions. In particular, Article 5, I quote, "The Sahara populations will themselves run their affairs democratically through legislative, executive, and judicial bodies, enjoying exclusive powers," end quote. This emphasizes that the autonomy of Sahara will be total, encompassing the three branches of government and benefiting from exclusive jurisdiction. In Article 12, and I quote again, "In keeping with democratic principles and procedures and acting through legislative, executive, and judicial bodies, the populations of the Sahara Autonomous Region shall exercise powers within the region's territorial boundaries, mainly over the following," and there comes a list of areas which actually include all the main areas of an entity enjoying almost full sovereignty, and among them are the region's jurisdictions, which will receive jurisdiction over all these areas. In Article 22, I quote again, "Courts may be set up by the regional parliament to give rulings on disputes arising from enforcement of norms enacted by the competent bodies of the Sahara Autonomous Region. These courts shall give their rulings with complete independence in the name of the king," end quote. Here again, this provision goes perhaps farther than in any system of devolution of judicial powers. The fact that regional courts will make the decisions in the name of the king should not be seen as a limitation, but on the contrary, as a source of legitimacy that will grant them full legal force in the whole kingdom. In Article 24, I quote, "Laws, regulations, and court rulings issued by the bodies of the Sahara Autonomous Region shall be consistent with the region's autonomy statute and with the kingdom's constitution," end quote. This is the legal framework within which the region will exercise its autonomy. The autonomy statute, resulting from negotiations with all the parties, confirmed by referendum, and the kingdom's constitution, which will incorporate this status of autonomy for the Sahara region. How is this question of devolution of judicial powers addressed in existing statutes of autonomy? We will now hear expert presentations and comparative analysis between these several cases of autonomous regions and the proposals included in the Moroccan initiative. The following questions could be addressed, and this list is only illustrative. Do the powers attributed to the autonomous region by its status include judicial powers apart from the executive and legislative competencies? If this is the case, are these judicial powers exercised independently from national judicial powers or concurrently? Do the powers attributed to the autonomous region apply to all areas of competency recognized to the autonomous region, or do the courts of the central state still exercise some powers in domain which are deemed strategic? Are decisions of regional courts applicable as a last resort in the autonomous region, or are they subject to appeal or cassation in national courts? Are there any mechanisms to solve conflicts between decisions of regional courts and national courts? Are regional judges and magistrates recruited, trained, and salaried? only in the framework of the autonomous region or also or solely in a national framework. The academics who will present their research today are Professor Joan Josep Valbe from the University of Barcelona in Spain, who will speak on Western Europe, Dr. Laura Stella Enong-Chong from De Montfort University in the UK, who will address Cameroon, Dr. Jean-Louis Roy, CEO of the National Quebec Library and Archive, who will talk about Canada, and Professor Yvonne Tu from the University of Georgetown, USA, who will focus on East Malaysia, Sabah, and Sarawak. And after their presentations, I will attempt to draw some conclusions. Now, I understand that Professor Yvonne Tu has to leave us at noon, New York time, so we'll probably give her the floor before Jean-Louis Roy. Without further ado, I now give the floor to Jean-Joan Josep Valbe. Sorry. Maybe just a few words about the speaker. He's a Sierra Hunter Associate Professor of Political Science at the University of Barcelona. And his research includes the empirical analysis of judicial behavior and, in general, the political economy of judicial politics. He gained his PhD in political science and organizational decision analysis from the University of Barcelona and a graduate degree in political science from the Autonomous University of Barcelona. Prior to his current position, he was researcher at the Institute of Law and Technology, visiting researcher at the Legal Information Institute of Cornell University, and postdoctoral researcher at the University of Amsterdam. He has a long list of publications, and we can, of course, share all these important works. The most recent one is Frameworks for Modeling Political Cognition and Decisions in Institutional Environments. Without further ado, I'm pleased to give in the floor.
Thank you.
The floor is yours.
Yes, thank you, Mark. Let me, it looks like I cannot share my presentation.
Okay, Majda, can you allow the speaker to share his presentation?
We will give him access 1 second.
Thanks.
Perfect. Perfect. I think it's working now.
Yes, good. Okay. Okay. Okay, so yes, I will start. Just thank you, giving thanks to the organizers and to Mark for letting me present this work. This has been because of the Corona crisis a long thing, but I'm very happy to be able to present this. So my work in this panel is to try to compare the provisions given in the Moroccan initiative regarding the judicial decentralization of the Sahara region compared to the countries in Western Europe. And when we look at the cases of Western Europe, but also outside Western Europe, we realize that although there's been a thorough movement of decentralization in terms of political and meaning executive and legislative decentralization across different countries in the world, judicial decentralization has rarely followed through this movement. So today it's still quite rare to find regions with fully developed judicial authority. As a result of that, we find very unequal development of regional judicial power across different countries, and now I'm focusing mostly in Western Europe. And one of the first conclusions we draw from that is that regional judicial power does not follow political decentralization always. So we find different scenarios of development. We can find countries such as Germany and Switzerland that have very, very advanced and thorough political decentralization, and also have very advanced and thorough models of judicial decentralization. But then we also can find countries with a notable degree of political decentralization, such as Spain or Austria, but that do not have an advanced system of judicial decentralization. And then we also find, of course, countries that have a fully centralized system with no decentralization whatsoever. Although there's an abundant literature on judicial federalism, which is the main, which should be at least the main field in which this issue should be developed, this literature has two main limitations, or at least two clear limitations. The first one is that due to the lack of presence of judicial, or the lack of a clear model of judicial decentralization in the world, we actually lack a common conceptual framework to study judicial decentralization, and completely unrelated to the conceptual scope developed for political regional authority, which is quite common and developed in political science. At the same time, this has produced some literature on judicial decentralization, but mainly based on case study methods that have very limited, in essence and by definition, a very limited generalization power. So we have a complete lack of comparable data. So my work in this paper tries to give an answer to the second of these limitations. So there was no space, and it was not the moment for developing a theory of judicial decentralization. But what I offer here is data and comparable data from Western Europe countries in terms of judicial decentralization, and a comparison with the Moroccan initiative for the Sahara region. So the main research question is how would an autonomous Sahara region, based on the provisions that Mark summarized before, how that region would compare to West European decentralized regions in judicial matters. And what I provide is a mostly descriptive analysis through a composite judicial decentralization indicator, which I created gathering data from all regions, from all 16 countries in Western Europe. So to create that indicator, I based my work on the very well-known notion of political authority by Gary Marx and Lisbeth and Hucke and Shackle, which is based at the same time in two different dimensions. So they divide regional authority in two dimensions. The first one refers to the capacity of regions to self-rule. And I adapted this first dimension to measure the extent to which regions in Western Europe can govern themselves in terms of judicial matters. And for that, I divided the concept of judicial self-rule, or I operationalized this concept through 5 different indicators. The first one refers to institutional autonomy. So to the extent to which regions have an acknowledged judicial system, and in terms of their capacity to recruit personnel, in terms of the way judicial maps are designed in regions and across countries. I then also take into account the extent to which regions have economic autonomy in dealing with the judicial matters. So do they provide, or do they have the ability to provide economic resources to handle their own judicial matters? And finally, whether there is some kind of last instance court within the boundaries of that region. So combined, my idea is that if we measure those 5 different dimensions of judicial self-rule, we can have more or less a quite precise idea of whether a region has or doesn't have a judicial self-rule. On the other hand, there's also a second dimension of regional authority, which refers to the extent to which countries allow regions to participate in high-level decisions regarding political matters, which I adapt to judicial matters. And I represent this second dimension with three different indicators. Mainly the extent to which regions are represented in the appointments of members of high courts at the federal or national level, whether they have some kind of participation in the way or in the organizations that control the judiciary, appointments, disciplinary actions, and things like that, and whether they do have some kind of control or participation in the decisions regarding how tax money goes to the management of the administration of justice. So more or less, I've already explained what those indicators or elements mean. And to give you just an example of the way I measure that, for every region, for instance, of recruitment, I devised like a point scoring system in which regions that do not have any kind of role in recruiting the staff for the administration of justice within their boundaries score 0, but regions that do have some kind of role have a range of points possible. So 1 point goes if the region recruits only administrative staff for the administration of justice. That would be, for instance, the case of my own region, Catalonia. 2 points if the region recruits administrative staff and at least one group of specialized staff, like forensic doctors, clerks of the court, and other experts. 3 points if the region complies with all the above and also recruits prosecutors. And finally, 4 points if regions are able to recruit their own judges in their own jurisdiction. So I applied all this to all these different elements. Of course, adapted to the meaning of every indicator, and then I measured them. And I did exactly the same with the second dimension, with the judicial shared rule. And to give you an example of that, with the first dimension of this, the representation element, I measured that in terms of whether regions do or do not participate in the appointment of members of high courts at the national level. So, and then I devised exactly the same kind of scoring system. So, what I gathered is a complete data set on all first level subnational entities of all West European countries from 1950 to 2020, actually, not 19, this is a mistake. Which gives us more than 15 region year observations, which is a data set that didn't exist before. I'm very happy to present this to you. And to normalize values, I summed all the values from each dimension and divided by the maximum score possible to have values that go from 0 to 1, so that they are very easy to interpret. The average regional judicial authority index overall across all years and countries is quite low, as I said at the beginning. So it's 0.19 or 0.2, but with quite higher level of variation. So the standard deviation is 0.3. There's slightly more variation in self-rule than in shared rule, which means that we will find more interesting information in the dimension of self-rule than in shared rule, because there's actually very low levels of shared rule across all West European countries. So this is more or less, this is the plot of the distribution of shared rule and self-rule across all West European countries. These are average estimates of for each country, and we find a picture that will repeat itself in most of the indicators. So we find Germany and Switzerland at the top of the distribution. They are two countries that have fully fledged political decentralized regions and judicially decentralized regions. And then we then find like a collection of countries that present fair levels of variation, which includes Belgium, the UK, Spain, Austria, Netherlands. And then we find like more or less 50% or 60% of the West European countries that actually do not have or do have very, very, very low levels of judicial decentralization. We also find, when we look at the data, that when we look at the data at the evolution of judicial decentralization within the countries, we find very low levels of variation as well, which means that when things are established, or for instance, when there are like regime changes or constitutional designs, constitution approvals, it is quite difficult to change these systems, because the judicial organization usually is part of the provisions of the constitutions. So, for instance, we find Austria, France, and the Netherlands, or Norway or Portugal, that have set levels of judicial decentralization at the beginning of the period, and they just do not change that throughout the whole period. But then we find some other cases. For instance, Spain. Spain is an interesting case here, because it started off with a zero level of judicial decentralization, but then with the approval of the constitution in 1978, so with the beginning of the democratic period, then different levels of judicial decentralization have been reached through time. And then we find the UK, which is an example of a very flexible constitutional system, in which we find moments in which some of the regions or some of the nations of the UK enjoyed different levels of judicial decentralization. And then we also find changes that decrease levels of decentralization, and then moments in which this level increases again. So regarding, I will go through, I will just not stop very long in each of the elements or dimensions, but I will go through all of them just to show you more or less the average levels in each case, and how the proposal for the Sahara region fits some of this or all of these dimensions. So regarding institutional autonomy, just recall that we mean by that the extent to which there is an official acknowledgement of the existence of a regional judicial system. This is a very, very rare thing to have. Only 2 out of the 16 West European countries do have an official acknowledgement of the existence of a regional judicial system. And currently, at the beginning of the period, and currently they are Denmark and the UK that also somehow address this thing officially. In terms of the comparison with the Moroccan initiative, Articles 5 and 12, as Mark recalled before, acknowledge that the Sahara region will hold a judicial system proper, which is a quite advanced feature regarding institutional autonomy. And if you look at the plot, only Switzerland and Germany, and then partially the UK and Denmark. Denmark scores very low here because it only applies judicial decentralization, and the acknowledgement of the existence of a regional judicial system only applies to Greenland and also to the Faroe Islands. So although they only refer to 2 regions, they acknowledge the existence of that system. Regarding recruitment, we also find a very, very similar picture. So only Germany and Switzerland score fully 4 points here. They recruit everyone. So the Länder in Germany and cantons in Switzerland are able to recruit the whole personnel that works in the administration of justice, from the last clerk to the last judge and prosecutor. So they score very highly here. The UK has a mixed system. Spain has also a mixed system in which regions some of the regions, including Catalonia or the Basque Country, can recruit administrative staff and some forensic doctors and things like that, but not judges or prosecutors or clerks of the court. And then we find a lot of countries, including Denmark, but also Italy, Ireland, and Greece, that in which regions do not have the capacity to recruit any of the members of the administration of justice. So the Moroccan initiative here in Article 22 hints to the possibility that the region itself should be responsible for the recruitment and appointment of the court personnel, which is also, as we see here, quite an advanced thing to provide for in terms of comparison. The third dimension is design, and here we find a slightly different picture. I will skip Switzerland and Germany because they always score very, very high here. But then recall that when we talk about design, we talk about the way, first, whether the map of judicial districts matches the map of regions. So if there is no an override of different maps when we overlap the political map and the judicial map, but also whether regions have the capacity to change the map of judicial districts. So whether they, within their own boundaries, they do have the capacity of redistrict. And here we find that most countries match judicial districts with regional boundaries, but regions cannot do any action on this map. So there is kind of a recognition that judicial districts follow more or less the same boundaries than political regions, but it is rare for regions to have the capacity of changing that map within their own boundaries. So in the initiative, there is no explicit claim about that. That is a very specific thing. And then we do not have any information about that. That doesn't seem, so if we look at the data, that doesn't seem a very essential feature for judicial decentralization if boundaries do match. Regarding economic authority, this is, I think, one of the indicators that better captures the limited capacity, so the actual limited capacity of most regions to have any kind of judicial power. So 75% of Western European countries do not provide regions with the capacity of funding courts and the judicial system. So this is the reality in those terms. And in that case, the initiative for the Sahara region allows for the region to exercise powers on its budget and taxation, which, combined with what we said about Article 22 on judicial autonomy, would be compatible with quite high scores in economic autonomy. So in principle, that could be the case, although of course it would need further elaboration. And then we have the last indicator for this first dimension, the fifth element, which is the last instance capacity. So the extent to which there is a high court with last instance capacity within the boundaries of regions. It is quite correlated with design, of course, because if so the existence of high courts at the regional level follows the way the judicial map is drawn. And we find quite less variation than I expected, I must say. The initiative for the Sahara region actually speaks about the highest jurisdiction of the high regional court on that region's legislation, and it could score very high as long as the regional parliament of Sahara has broad legislative powers. So it could, if designed in a way that the parliament has broad legislative powers on several relevant issues, then the High Regional Court in the Sahara region would have a very relevant role here. So this would be also an advanced feature regarding the way it is designed in Western European countries. Going now, so making more or less a wrap up of this first dimension, we find like 4 different scenarios of regional development in terms of judicial matters. We have like high-level regional judicial self-rule with Switzerland, mainly Scotland in the UK and Germany. Then a few mid-level cases, such as Denmark for Greenland, especially, and Northern Ireland in the UK again. And then we have very low level of judicial decentralization in Spain, in some periphery in France, Belgium, Austria, and Portugal, and then absence of self-rule whatsoever in the rest of the countries of Western Europe. If we go to the second dimension, the shared rule dimension, I will go very quickly here because I have to say that the initiative for the Sahara region actually does not provide actually for the region to participate in decisions regarding judicial organization at the national level. But for the sake of completeness, I will just present the main results here. So in terms of representation, so whether regions have any kind of decision, of capacity of decision to appoint or influence the appointment of members of the high courts at the national level, only 5 countries in Western Europe have some sort of regional representation in those courts. In Germany, there's the full participation of land ministers in those appointments, but then in most countries, this does simply not exist. Regarding the executive control, so whether regions do have any kind of participation in the organization and the functioning of the public organizations that control the way judges are appointed or are removed or are disciplined, we find a very, very similar picture than the one before. So only a very, very few cases there is some kind of regional participation in the governing body of the judiciary, mainly Switzerland and Germany. We find some of this in Belgium, but mostly in the rest of the countries, we find nothing regarding that. And finally, regarding the participation of regions in the fiscal control, so in the way the extent to which regions have a say on the way tax money goes to the organization of the judicial system, we find a lot of variation. I must say that this indicator does not only refer to judicial matters, but it's just a general indicator of the participation of regions in the decisions regarding the fiscal distribution of tax money. And there's no indication about that either in the Moroccan initiative for the autonomy of the Sahara region. So in Western Europe, we find also 4 different scenarios of development of the shared rule. In terms of regional judicial organization. High-level reference countries will be Germany and Switzerland as ever. Mid-level reference countries here will be Belgium and Denmark for Greenland and Scotland again. And low-level reference countries would be Austria, Finland, the Netherlands, Sweden and Spain. And then we find France, Greece, Norway, Portugal and Ireland, which have a complete absence of shared rule. So wrapping up, quickly, the indicator I just presented very quickly points to the existence of different scenarios which are possible for the initiative for the Sahara region, because there is not a homogeneous pattern either in judicial self-rule or shared rule. In general, we find always higher values in self-rule than in shared rule. Shared rule seems to need more advanced federal system at the national level to be able to be fully developed. And as of now, the Sahara region would score rather high as of the provisions given in the document, in judicial self-rule, and especially in institutional autonomy, recruitment and design, but also quite in medium level of economic autonomy and last instance capacity. So thank you very much. I hope I'm not spending too much time on that. Thanks.
No, thank you very much, Jean-Joseph. It's been very interesting. Of course, as you mentioned, there is little literature, little research on this issue of devolution of judicial powers. So your contribution certainly is invaluable. And thank you for having taken the time to compare your research on Western Europe with the provisions for the autonomy of Sahara. And will just maybe as a takeaway, retain your main conclusion that these provisions are actually, once implemented, would represent a major advance in terms of self-rule or devolution of judicial powers, including compared to countries with a high degree of institutional autonomy in Europe. So thank you so much. And now we move to the second speaker, Laura Enonchong. I will briefly introduce her. If I find my documents. Sorry for this brief introduction. So Dr. Laura Stella Enonchong is a senior lecturer in law at De Montfort University in Leicester, United Kingdom. And her research interests are in the field of comparative constitutional law, international and comparative human rights law and governance, particularly in countries of the Global South, the African Union, the African human rights system. Her recent scholarship has focused on constitutional governance in Cameroon, international constitutional law and the protection of disability rights under the African Charter on Human and People's Rights. Previously, she was associate lecturer at the University of Warwick, deputy coordinator of the civil society organization, the Opportunity Foundation. She also acts as expert consultant on issues of constitutionalism in Africa and has provided advice to international and regional organizations such as the World Bank, the International Institute for Democracy and Electoral Assistance, and the African Union Commission on aspects relating to human rights, refugees, and constitutionalism in Cameroon. She also has contributed to civil societies organizations in Birmingham working with refugees, which include the Refugee Action, where she worked on the CARE project, and the Birmingham Refugee Council, where she worked on the Women's Project, winning the Regional Marsh Awards for designing a project on social integration of refugees in Birmingham. Her most recent publications include Constitution and Governance in Cameroon, and she will actually give us a sort of insight and summary of this publication. I must particularly thank Laura because she agreed to contribute to our seminar with a very short notice, and therefore she didn't have the time to do an extensive research and comparative study with the Moroccan initiative. But of course, like the other speakers, she will write a full-scale, full-fledged article that will probably be published by Morocco, like the other speakers' contributions. And now the floor is yours, Laura.
Good afternoon, good morning, everyone. Thank you, Mark, and thank you to the organizers. It is a pleasure to contribute to this very important debate. So before I start, I don't know if I'm able to share my screen. I'll try that. Okay, that works. Thank you. So, so the purpose of my contribution today is simply to analyze the position in Cameroon with regard to judicial devolution in the northwest and southwest regions of Cameroon, which have a special autonomy status, and to attempt to compare that with the provisions of the Moroccan initiative. So as Mark said, my conclusions on this will be a bit temporary because I have not, or rather tentative, because I have not spent much time to immerse myself into the dynamics of the Moroccan initiative. But to begin with, I would just provide a brief structure of how this presentation is going to go. So I will talk about, I will provide a historical background to understanding the problems in Cameroon today, which led to the establishment of a special status, or the granting of a special status to the Northwest and Southwest region. And we'll talk about the provisions on judicial autonomy, or the lack thereof, and compare that with the Moroccan initiative, or just to see what insights the Cameroonian position presents that could be instructive to the Moroccan initiative as it's been developed and refined. So very briefly about the history of Cameroon. This is important because it helps to understand how this Northwest and Southwest region, the English-speaking regions, which are minority, came to be granted a special status. So Cameroon, as we know it today, or the Republic of Cameroon as we know it today, was previously a League of Nations mandate, and subsequently a UN trust territory under the control of Great Britain and France. Now, both colonial powers had various portions of Cameroon. The British took a smaller portion of Cameroon and divided this portion into British Southern Cameroon and British Northern Cameroons. But we don't talk about the British Northern Cameroons anymore because at independence, they decided to join Nigeria. So today they form part of Nigeria. Now, both countries ruled their territories separately, implementing their own laws, civil law in the French Cameroon and the common law in British Southern Cameroons until the French Cameroon gained independence in 1961. But it was a bit of a tenuous journey to independence for Southern Cameroons because at the time, the British did not think that the Southern Cameroons was financially and administratively ready for independence, but it could not, it did not want to carry on colonial administration, and the UN was keen for Southern Cameroons to become independent. So in the end, the British administration and the UN decided that there should be a plebiscite where Southern Cameroonians would decide where, how they wanted their independence. And the only two options they were given was whether to join Nigeria or the newly independent French Republic of Cameroon. Now, Nigeria was an option because Southern Cameroon had been administered during the colonial period as part of Nigeria. So at the plebiscite, Southern Cameroonians chose to gain independence by joining the Republic of Cameroon in October 1961. So I'll show you a map here of Cameroon just to put the discussion in context. the blue parts represent the French-speaking areas of Cameroon, which apply the civil law, and the red or pink area on the sides here towards, so you have the Northwest and the Southwest, the two regions which are English-speaking and apply the inherited common law system. So you see that this constitutes just 20% of the whole population. In terms of territory, population size, the Anglophones are a serious minority. So this has always been an issue in Cameroon in governance. Now, post-independence constitutional designs, once Southern Cameroon decided to gain its independence by joining the French Republic of Cameroon, there's constitutional system that was adopted in 1961 after the reunification was a federal system to allow for both territories to be able to continue, to allow some continuation in terms of their administration, and specifically with regards to the language issue and the judicial system. So the Constitution attempted here to preserve these inherited legal traditions, but the government started a process of harmonizing laws. They started with the criminal code, which was harmonized, but it was mostly influenced by principles of French civil law. Then in 1972, the federal structure was abolished in the referendum. So the country moved from federalism to a unitary system. In effect, the two federated states of West Cameroon, which represented the English-speaking section, and East Cameroon, the French-speaking section, no longer existed because of the unitary structure that had been adopted. Now, in terms of the judicial system, it became a uniform judicial system, but very much civil law oriented. So at the national level, you had all the courts that existed when during the French colonial administration, which had now been adopted to fit within the new structure established in Cameroon. But these civil law-oriented courts were also now being established in the English-speaking regions, which obviously apply the common law. So you already begin to see that divide. There is a problem there in terms of legal traditions, legal cultures. But the 1972 Constitution continued to recognize that dual legal tradition. Now, fast forward to 1996, when a new constitution was adopted. So this constitution provided for a decentralized system, but this did not come into effect until about 2019, when the law, a regional code was adopted. I will get to that in a few minutes. But this constitution recognized that dual legal heritage, and it's enshrined in Article 68 of the Constitution. So English common law continues to be applied in the English-speaking regions, but within a court structure, a judicial structure, which is essentially civil law oriented, while the civil law continues to apply in the French-speaking regions. Now, the judiciary is regulated nationally. So these regions did not have, and still do not have judicial autonomy. I will get to that in a minute. But because of these difficulties, Anglophone lawyers, the English-speaking lawyers, had a lot of problems, because in addition to all of this, the training of judges takes place within the National School of Administration and Magistracy, which is in Yaoundé, the capital city. And the training did not make any distinction as to where these judges would be working. So judges were trained in the civil law system, but they would be appointed to serve anywhere in Cameroon because of the uniform court structures. Now, the problem here was that in the English-speaking region, there were judges who did not have the language competency. They could not speak English sufficiently to be able to work in the courts to administer justice properly. In addition to that, they did not have the common law background. They did not understand principles of common law practices and procedures. So there was kind of a disconnect. And this led to a breakdown of communication between the lawyers and the courts. Now, the lawyers had repeatedly requested the government to deal with this problem because it prejudiced litigants from these regions. Once the lawyers stopped working and stopped going to court, then the litigants did not have any recourse to the court and could not have judges to adjudicate on the matters that, the issues, the problems that they might be having within the community. So eventually, because the government did not respond to the call from the lawyers to address the problems, the lawyers took to the streets in peaceful protest at the government's lack of response. The government responded to this protest with disproportionate force, arresting some of the lawyers, detaining them arbitrarily. So this caused the rest of the English-speaking populations to be really aggrieved, and it awakened already existing grievances about the marginalization of Anglophones. I mean, this has always been there, but it has been in the background for many years. The treatment of the lawyers just provoked these grievances again, these grievances of marginalization of Anglophones. And by the time we knew it, there were widespread protests in the streets, and those who favor federalism started asking for a return to the federal system that was instituted in 1961. Then there are others who asked for, were demanding for secession. Now the secessionists finally got hold of arms, and by the time the country knew what was happening, there was a civil war in the English-speaking regions. A lot of atrocities committed, as you would expect under such circumstances. So responding to domestic pressure and international pressure, the government eventually held a national conference to try, amongst other things, to resolve this conflict. One of the recommendations that was made at the conference was that the Northwest and Southwest regions should be granted a special status, special autonomy status. Shortly after the conference, the government prepared a bill on decentralization, which included the special autonomy status for the Southwest region, and it was quickly passed by Parliament. The problem is that this was not discussed with anyone. The Northwest or Southwest regions were not consulted. There was no contribution from anyone else to draft this legislation or to comment on any drafts. They were not given that opportunity. So once the law was passed, it had mixed reactions, where it was received by some parts of the population, very little, let's say a majority of the people rejected this document because they felt that they were not consulted, and it did not actually provide the kind of powers that regional autonomy or the kind of powers that would allow the English-speaking populations to control or to regulate their own internal affairs. So that's the context within which the Southwest and Northwest regions were granted special autonomy. So in relation to judicial powers, which we are really concerned with today. So as I mentioned before, the regional and local authorities code is the primary legal instrument on decentralization and special autonomy status for the Northwest and Southwest region. It vests the decentralized authorities in the 10 regions of Cameroon with some devolved competencies in the areas of economic development, health and social development, education, sports, and cultural development. In terms of the organizational structure, the regions are composed of a regional council, which is the deliberative organ, and the president of the regional council, which is the executive organs. So together, these two organs are in charge of the administration of the regions, of all the 10 regions in Cameroon. The code made special dispensations for the English-speaking Northwest and Southwest regions to take account of their specificities, especially in the English language, the education system, and the judiciary, or rather the legal tradition. Now, the normative framework for the special status is based on Article 62 of the 62 sub 2 of the Constitution. And this provides that the law may take into consideration the specificities of certain regions with regard to their organization and their functioning. This is confirmed in Article 327 of the Regional and Local Authorities Code, which makes reference to the fact that the special status has been established in accordance with Article 62 of the Constitution. Now, in terms of what the kind of specificity or the way that the specific legal tradition has been recognized, Section 3 sub 1 of the Regional Local Authorities Code provides that the Northwest and Southwest regions shall have a special status based on their language specificity and historical heritage. And that it provides further that the special status shall entail consideration of the specificities of the Anglo-Saxon legal system based on the common law, and that the English-speaking regions may also be consulted in the formulation of judicial policies in the common law subsystem. Now, beyond these provisions, there is no specific devolution of judicial powers. So as the earlier speaker said, this is quite a novelty, the complete devolution of judicial powers to special autonomy regions or to decentralized entities. So like other regions in Cameroon, the English-speaking regions have those defined competencies in economic development, health, social development, education, and cultural development. They have no powers to establish local courts and tribunals or powers to recruit and train judges and judicial personnel. So all of this is regulated at the national level. So all courts in all the 10 regions of Cameroon are similar, well, are pretty much the same. The court structure is the same in all the regions, starting from the customary courts or courts of first instance, which are right at the bottom, and you have the High Court, military tribunals, lower audit courts or regional audit courts, regional administrative courts, the Special Criminal Court, which is situated in Yaoundé. This court in particular, the Special Criminal Court, has national jurisdiction because it tries, it has jurisdiction to try to hear matters relating to the mismanagement or misappropriation of public funds where the amount exceeds 50,000 or rather 50 million CFA. Now, at the apex of all the courts is the Supreme Court, which is located in Yaoundé, the capital city. Now, the Supreme Court is the final court of appeal. So appeals from all the regions, including the common law regions, go to the Supreme Court. Now, the problem with this organizational structure is that in terms of the special autonomy regions, they apply the common law, whereas the Supreme Court is a civil law-oriented institution. Historically, that has posed many problems, including the issue of language and also the different tradition, the different legal tradition. So cases from the English-speaking region would naturally be in English, whereas most of the judges in the Supreme Court speak French. And the common law has different legal principles, different practices and procedures. And so this raises issues of conflict of laws. So how are these dealt with? The Constitution provides no specific mechanism for resolving this conflict. This is dealt with internally. No other legislation, not even the regional or local authority code, deals with that. Now, some of these issues were underpinned the grievances of the English-speaking lawyers when they protested in 2016. And due to, so the government tried to address this by creating a common law division in the Supreme Court in July 2017. Now, the common law division was meant to address the absence of, or rather to represent or to accommodate the common law within that broader structure of the Supreme Court. So in terms of jurisdiction, the common law division has jurisdiction in matters relating to the common law to hear appeals from courts against on any matter that has been decided on the basis of common law. So this measure goes a long way to ensuring that the legal tradition of the autonomous region is to an extent accommodated within the Supreme Court. And it gives consideration to the training and background of judges to be appointed to that division, because the law states that the judicial personnel appointed to the common law judicial division should have an Anglo-Saxon background. But there are other issues with this law which really do not deal with the problems with regard to the common law within a wider civil law system. Firstly, the provision on the common law division exists outside of the framework of the special autonomy. So cases from this region still have to go to the Supreme Court. So the autonomous regions do not have any control over that common law division. They have no powers over that division. Everything still remains decided centrally. The subject matter jurisdiction of the common law division is still not very clear. And then thirdly, the legislation makes no provision for the resolution of conflict of laws. So those problems still persist. How would specific common law principles that do not apply in the civil law, how would they be dealt with at the level of the Supreme Court? Would the common law division just simply ignore all of the other procedures within the Supreme Court and apply common law procedures? So these issues have really not been dealt with. It's still new. The court is still new. It's still early days. So perhaps as things progress, these issues will be dealt with. Now, in terms of training, judicial tenure and training, so the judiciary is, judicial tenure is regulated by the Constitution and other legislative instruments. So the Constitution provides that judicial power shall be independent of the executive and legislative powers, and that the president is the guarantor of judicial independence. Now, in exercising that duty, he's assisted by the Higher Judicial Council, which gives an opinion. The role of the council is simply advisory, so it cannot make any binding recommendations. Another issue with that institution is that it is influenced by the executive. For instance, the President of the Republic is the chairperson of that institution, and the Minister of Justice is the vice chairperson. So in terms of independence, it's difficult to see how that council, that institution, can't advise the same president who chairs it. So this is an issue with regard to judicial independence. It undermines judicial independence and the rule of law, as judges often are not able to hold the executive to account. Now, to add to these difficulties is the problem that the judiciary is institutionally linked to the Ministry of Justice, so that the minister is the hierarchical superior of judges. So both the individual independence and the institutional independence of the judiciary is severely compromised. Now, in terms of the training, as mentioned earlier, the judges are all trained in the National School of Administration and Magistracy. Now, one of the problems that I mentioned earlier was the fact that Anglophone, or rather, the training did not make any distinction as to where these judges will be practicing or will be working, because of the national structure. They could be appointed to serve anywhere in the 10 regions of Cameroon, whether the regions were English-speaking or French-speaking. And the training in ENAM, in the National School of Administration and Magistracy, is civil law oriented. So because of the protests that started in 2016, which led to the civil conflict, the civil war, the armed conflict, the government created a section within ENAM to train the common law judges. So in terms of training, that has addressed the problem of training all the judges in the civil law system. So now we have judges being trained in the common law system and also in the civil law system. That would help to ensure that, you know, judges who go to the English-speaking regions can actually speak English and understand the common law judicial traditions. Now, so in a nutshell, that's the Cameroonian experience. So judicial power, there's no devolution of judicial power in the context of the special autonomy of the Northwest and Southwest regions. The judiciary continues to be regulated nationally, and the same law, the same system applies to all the 10 regions, irrespective of the judicial tradition. So a brief look now at the Moroccan initiative. We have had some details already about the Moroccan initiative, but here I've just reproduced some of the relevant provisions of that document. I note also that the national judicial structure in Morocco, as provided for under the 2011 constitution, appears to have gone a long way to guarantee judicial independence compared to what existed in the previous 1996 constitution of Morocco. So in that respect, it has gone a lot further than the system in Cameroon. And again, looking at the provisions of the Moroccan initiative, we can note here, and said also by the previous speaker, that it is very advanced in terms of devolution of judicial powers. So I note that one of the things that the initiative introduces is it makes provision for devolution of legislative, judicial, and executive powers. And it states that courts may be set up by the regional parliament to give rulings on disputes arising from the enforcement of norms enacted by competent bodies of the Sahara Autonomous Region. And that these courts shall give their rulings with complete independence in the name of the king. So there we can already see that it is quite advanced compared to the Cameroonian position. And it also makes provision for the establishment of the High Regional Court, which is the highest court, or which would be the highest court in the Sahara region. And also the final provision there, which talks about laws, regulations, and court rulings being issued by, which are issued by the bodies of the Sahara Autonomous Region, that they shall be consistent with the region's autonomy statute and the kingdom's constitution. This also is not unusual in terms of constitutionality and trying to maintain a coherent constitutional system. So that's the framework, that's the current framework of the Moroccan initiative. And because I haven't really immersed myself into the specific details, my conclusions here or my reflections here are kind of tentative, and they will be developed a bit further for publication. But the question that I will ask here, in the context of the differences in the two systems, Cameroon's judicial powers and devolution, and the Morocco initiative, the question is, so what can the experience in Cameroon contribute to the Moroccan initiative? So I have a few insights here that I have outlined and hope to develop further, but these are based on the experience of Cameroon and looking at the Moroccan initiative. So firstly, one can think about, consider whether the nature of judicial power at the regional level. So whether how clear the scope of judicial power is. So it should be clearly outlined. Judicial power at the regional level should be clearly outlined and more comprehensively defined, including the different subject matter jurisdictions, for instance, in areas of commercial law, private law, criminal law. And consideration of the historical structure of the judiciary and the exercise of judicial power and how it's going to be developed within this new structure as it is contemplated. Now, in Cameroon, the special autonomy did not seriously consider the effects of the current judicial structure on the continued existence of the common law. So perhaps the important insight here in terms of the Moroccan initiative is that it should take into account the structure of judicial power and the way it is currently exercised within the Sahara region and nationally. And well, this means that consideration should be given to issues like the appeal structure, whether the decisions of the regional high court on the interpretation of legislation enacted by the regional parliament is final, whether decisions from the high judicial or the high regional court can be reversed by the Kingdom Supreme Court or the Constitutional Court, and the competence of any court set up by the regional parliaments, whether they can decide on disputes arising from laws enacted by relevant national bodies. So this should be taken into account as the initiative is being developed. Now, the Cameroonian special autonomy structure also provides no mechanism to for the resolution of conflict of jurisdiction, in spite of the potential conflicts which can exist because of the different legal traditions and having courts at different levels. Now, given that the Moroccan initiative envisages a structure where some competences fall within the jurisdiction of the region, it would be necessary to have a clearly outlined normative framework and procedures for potential conflicts of jurisdiction with national judicial institutions. And also to take into account the extent of regional autonomy in the exercise of judicial powers, e.g. in terms of recruitment and training of judges and judicial personnel in the courts created by the regional parliament. Oh, I'm running out of time, but I'm almost there anyway. Because judicial power in Cameroon remains very centralized, it continues to be a problem in view of the different processes of judicial training in the civil law and in the typical common law legal tradition. Now, everything is controlled centrally, so there is no distinction there. But so in terms of, again, another insight from the Cameroonian experience is that these arrangements on the special stages did not result from a broad consultative process. So perhaps this would have given the opportunity to address some of these issues relating to the common law system and how it can be regulated better within the structure of the regional autonomy, within the framework of the law that guarantees a special status for this region. So perhaps the insights that can be learned from this in terms of the Morocco initiative is that it should continue to pursue an inclusive approach which acknowledges and respects a difference. Okay, I think I've run out of time, but that's pretty much what I had to share with you today. Thank you very much.
No, thank you, Laura, and thank you for having made this effort of precisely addressing not only the case of Cameroon, but also comparing it with the provisions of the Moroccan initiative. And of course, there are several points that are similar and some that are different, but we can come back to this in the Q&A discussion. So without further ado, we move to the next speaker, Professor Yvonne Chu, Professor of Law at Georgetown University, She writes and teaches constitutional law, comparative constitutional law, global law and religion. She wrote, in particular, constitutional statecraft in Asian courts. Her scholarship is being published and is forthcoming in many journals, including the American Journal of Comparative Law, Virginia Journal of International Law, Columbia Journal of Transnational Law, Cambridge Law Journal, Washington International Law Journal, as well as book collections from Oxford University Press, Cambridge University Press, and Edward Elgar Publishing. She was guest columnist for several blogs and publications, and she holds a PhD from the University of Cambridge, where she was a Gates Cambridge Scholar. Her doctoral dissertation was awarded the Distinction in Research Prize in the Arts and Humanities by St. Catherine's College, University of Cambridge. And while she was there, she served as the editor-in-chief of the Cambridge Student Law Review. She received her first law degree from the University of Cambridge, graduating with double first honors. She graduated with the Master of Laws from Harvard Law School after winning the Cambridge-Harvard Law Link Scholarship, awarded to the top 2 final year law graduates from the University of Cambridge, admitted to Harvard Law School. And she's a member of the New York State Bar. And before joining Georgetown Law, she held a postdoc research fellowship at Columbia Law School and was a Hauser Global Research Fellow at the New York University School of Law. And she, as I said, she wrote many books and other publications. So she will speak about the case of 2 autonomous regions in East Malaysia. And I'm pleased to welcome her to the floor now.
Thank you very much, Mark, for that generous introduction. And thank you to the UN Permanent Mission for having me here today. I'm very glad to be with all of you virtually today. I have a PowerPoint presentation as well, which I'll just use as an outline for my talk. I'll be speaking on devolution of judicial powers in East Malaysia. I'm currently at Georgetown Law. I'm happy for you to contact me. My contact information is on my bio page, which is also available online. And so this is the outline of the talk today. I'm going to walk through 4 main points. The first is I'll say a little bit about the historical and constitutional context of the Federation of Malaysia, under which the structure we have the East Malaysian states of Sabah and Sarawak. And then I'll provide an overview of the devolved system of judicial powers in East Malaysia, under which Sabah and Sarawak exercise some degree of independent and concurrent judicial powers, along with the federal judicial powers of the rest of Malaysia, And then third, I'll offer some evaluation on how the devolution of judicial powers in East Malaysia has operated in practice over the past 6 decades. And then finally, I'll conclude with some broader observations, albeit tentative, on how the East Malaysian experience might inform the proposals for the devolution of judicial powers outlined in Morocco's initiative for the autonomy of the Sahara region. Okay, so with that, let's move to the first point, where I'll just sort of set out a brief overview of Malaysia's history and constitutional context. So we're moving across the world now to Southeast Asia and to Malaysia. This has been such a tour of all the different parts of the world, and I've been very grateful to hear from all the other speakers on this. Malaysia, and here we are, is composed of a federation that is the peninsula of Malaysia, plus the Borneo states of East Malaysia, Sabah and Sarawak. It became a fully independent, the Federation of Malaya, which would be the peninsula that you saw in the map earlier, became a fully independent state in 1957, on August 31st, 1957. That's our first Prime Minister, Tunku Abdul Rahman, declaring the independence of Malaysia on August 31st. And it was after that, 6 years later, in September of 1963, that Singapore, as well as the Borneo states of Sabah and Sarawak, joined Malaya, creating what was then the new Federation of Malaysia. Singapore would later leave the Federation, and 2 years later, it's a separate topic altogether, but the Malaysia Agreement of 1963, as you see here, created a new federation that was signed by the UK and included Malaya, Singapore, and North Borneo, now Sabah, and Sarawak. So under this 1963 agreement, this is now the current map of what the Federation of Malaysia looks like, no longer with Singapore in the picture. So we have the Federation of Malaya, the Peninsula Malaya context, and then the Sabah Sarawak context. The Malaysia Agreement, under the Malaysia Agreement of 1963, the states of Sabah and Sarawak were granted a fairly extensive degree of autonomy in the proposed federation. Autonomy was clearly a high priority issue for the leaders of Sabah and Sarawak, who wanted to retain a high degree of autonomy in agreeing to join this new federation, the Federation of Malaya, to become the Federation of Malaysia. And so the 1963 agreement is a significant document because it lays out the conditions under which the Federation of Malaysia was established, and in particular, it gave these states, Sabah and Sarawak, a pretty high degree of autonomy in the new federation. For example, the two states were given control of immigration, and following what was known as the 20-point agreement, which was like 20 points between the Borneo leaders and the other leaders, the federal constitution was amended in 1963 with the inclusion of these states to include provisions that provided for the special status of Sabah and Sarawak. These states were given extra legislative and executive powers and funding, and some degree of enlarged representation in the federal parliament, and significantly, safeguards were inserted in the constitution in relation to any amendments relating to these states. It's worth noting that the terms of Sabah and Sarawak's entry into Malaysia were fairly flexible and even more so than those accorded to the other state that joined the Federation of Malaysia at that time, Singapore, in areas such as citizenship rights and representation in the federal legislature. Okay, so with that, I'll now move on to say a little bit about the legal system as a whole of Malaysia, Malaysia's constitutional context and its judicial court structure, since we're talking about judicial powers. Very briefly, the Malaysian constitutional context is a Westminster model parliamentary system where the Prime Minister and Cabinet are drawn from the majority party in Parliament, and it also has a constitutional monarch, the King, which is the constitutional head of the Federation. The Constitution itself is declared the supreme law and also includes a Bill of Rights and Fundamental Liberties. And the general rule for amending the federal constitution is 2/3 of the total membership of each House of Parliament. Although I'll note at this point that amendments to provisions concerning the position of Sabah and Sarawak require the consent of the respective state governments. So that is one of the special provisions given to the Borneo states of Sabah and Sarawak. As regards the judicial system, Malaysian courts have a strong power of judicial review. By that I mean courts can, under the Constitution, strike down legislative and executive actions for unconstitutionality as a corollary of the Constitution's supremacy clause. And Malaysia has a legal system that consists of what we might call the civil court system, consisting of superior appellate courts. This will be fairly familiar to any of you from a common law context. We have the federal court or the Supreme Court, the Court of Appeal, which would be the second appellate court, and then the High Court and the High Court under that. And there are two High Courts, one for Malaya and then the High Court for Sabah and Sarawak. Malaysia also, I'll note, has like a separate system of religious courts, the Sharia court systems, which is established under individual state governments that have jurisdiction over persons who profess the religion of Islam in respect of matters governed by state Islamic law, such as personal and family law. So moving back to the judicial system in Sabah and Sarawak then, and just to bring in, to show you again, the High Courts of Malaya and High Court of Sabah and Sarawak. Prior to the formation of Malaysia in 1963, there was a combined judiciary in place for Sarawak, Sabah, and Brunei. And when Sabah and Sarawak joined the Federation of Malaysia in 1963, the High Court of Sabah and Sarawak retained its jurisdiction, but the ultimate appellate jurisdiction was assumed by the Federal Court of Malaysia. Nevertheless, East Malaysia continues to maintain a high court of its own. Both high courts in the Constitution, it stated there are the two high courts of coordinate standing. Both these high courts have general supervisory and appellate jurisdiction, as well as unlimited civil and criminal jurisdiction, and each is headed by its own Chief Justice. In addition to the High Court of Sabah and Sarawak, the East Malaysian states also have subordinate courts. So this would be like the subordinate courts under the appellate court system. These include the Sessions Court, Magistrates Courts, and the Native Courts. Those courts have jurisdiction over the native courts have jurisdiction over native laws and customs, as well as on some matters of on land disputes, and they are treated in a similar fashion in some ways to the state Sharia courts, the religious courts, in that the civil courts do not generally interfere with or enforce judicial precedent over decisions that are issued by state Sharia courts or state native courts. So with that, I'll say a little bit about the independent and concurrent judicial powers that are shared between the High Court of Sabah and Sarawak as well as the federal court system. In terms of concurrent judicial powers, I suppose most obvious to note is that the Malaysian Federal Court and Court of Appeal, the two highest appellate courts in the country, do have appellate jurisdiction over the High Court of Sabah and Sarawak. So it is not completely autonomous in the sense that the higher appellate courts have review powers over decisions in the High Court of Sabah and Sarawak. However, in terms of independent judicial powers, the High Courts of Sabah and Sarawak have wide jurisdiction to hear cases and disputes that take place in Sabah and Sarawak, and their subordinate courts also handle matters within their jurisdiction. So while the High Court of Malaya hears cases and disputes within Peninsular Malaya, the High Court of Sabah and Sarawak hears cases and disputes that take place in Sabah and Sarawak. And the Malaysian Constitution grants Sabah and Sarawak special power to veto amendments to the Constitution that affect their states, and also on other matters. These matters include the constitution and jurisdiction of the High Court of Sabah and Sarawak itself, and the appointment and removal and suspension of its judges. So we see here sort of a reflection of a constitutional special protection for the judicial system of Sabah and Sarawak, in line with a guarantee that these states should essentially maintain a large degree of autonomy over its judicial system and legal profession. In terms of the exercise of judicial powers by the judges, a judge of the High Court of Sabah and Sarawak, according to the Constitution, exercises, to quote, all or any powers available to a judge of the High Court in Malaya. And it's worth also noting that cases cannot be transferred between the High Court in East Malaysia and the High Court of Malaya, or vice versa. The High Court's decisions, each High Court, are enforceable throughout the entire country, not only within a particular territorial system. A judgment of the High Court of Sabah and Sarawak is thus effective throughout the Federation of Malaysia. Although, as noted before, those decisions are subject to appeal, and the Federal Court and the Court of Appeal both have appellate jurisdiction over the High Court. So in terms of judicial appointments and legal practice, the Chief Justice of the High Court in Sabah and Sarawak is the highest position within the East Malaysian legal system. However, judges and lawyers from Sabah and Sarawak may be appointed to higher federal appellate courts like the Court of Appeal and the Federal Court. Indeed, in 2018, the Chief Justice of Sabah and Sarawak, Richard Melanjum, became the first Borneo Chief Justice to be appointed as the Chief Justice of Malaysia. Although Justice Melanjum served for only 9 months or so before retiring in 2019 when he reached the mandatory retirement age, his appointment to the nation's top position was very well received by many East Malaysians as a sign of the state being regarded as an equal partner in the Federation. In terms of legal practice, there are separate bars for Peninsular Malaysia and for Sabah and Sarawak. And members of one bar association are not admitted to practice at the other state bars automatically. So a member of the bar council is not entitled in Malaysia, in Peninsular Malaysia, is not entitled to practice in Sabah and Sarawak, and similarly, vice versa. Efforts for a more unified bar have generally been brought up, but also have encountered some degree of resistance, including by lawyers from Sabah and Sarawak, who appear concerned about an influx of lawyers from West Malaysia to East Malaysia if that were to be the case. So having given an overview of the judicial powers in both West and East Malaysia, I'll now move to the third part of my talk, which is a sort of general evaluation on the East Malaysian experience, and I identified sort of 3 general areas in which that have become topical when speaking about the East Malaysian devolution experience in recent times, or over the past Malaysian experience of the last 5 decades. I mean, one issue that has arisen is the legal constraints on the federal government's power to interfere with the state government, and how those constraints may or may not have been particularly effective when invoked through an emergency regime, a regime of emergency powers. Emergency powers do afford the federal government a great degree of latitude, which then could overcome some of the legal constraints and some of the special protections for the autonomous states, for the particular state governments. One example here, an illustrative example, involves the dismissal of the Sarawak chief minister in 1966. The chief minister at that time, Stephen Kalungningkan, refused to accept his dismissal by the governor of Sarawak. And interestingly, the High Court of Sabah and Sarawak held that the dismissal of the chief minister was unlawful, allowing the chief minister to resume office, reasoning that a vote on the floor of the state legislature was necessary to determine the confidence of the majority. The federal government then proclaimed an emergency. And under that emergency regime, the federal and state constitutions were temporarily amended so that the state governor was given the power to dismiss the chief minister. So thus, by invoking emergency powers, the federal government thus in effect overruled the decision of the High Court. And as some scholars have, like Andrew Harding and others have noted, as an extensive regime of emergency powers that are invoked by the federal government in these kinds of circumstances allows for an extensive ability to intervene in the state government, despite the special constitutional protections that the East Malaysian states receive under the Constitution for judicial power and for constitutional amendments. And then a second relevant issue for the East Malaysian states has been the protection of interests and indigenous interests and rights. The indigenous peoples of Sabah and Sarawak constitute approximately 40% of the population in Sarawak and 60% in Sabah. And on the one hand, the devolution of judicial powers in Sabah and Sarawak appears to have developed in recognition of these states' unique customary laws, which are deeply rooted and enforced through the legal system. The design of these states' judicial system and legal profession, as we have just seen, appears aimed at protecting the legal profession in Sabah and Sarawak and preserving their unique legal history, laws, and legal culture. The special position of the East Malaysian judiciary is also attributed in part by their native law, which represents a substantial parts of the legal systems of Sabah and Sarawak and is not a legal subject necessarily known to the Malaysian judiciary as a whole. Thus, we saw, as we discussed earlier, some of the provision of native courts to deal with some of these issues and the protection for these courts under the legal system of Sabah and Sarawak. On the other hand, it's worth noting again that the Malaysian Federal Court and Court of Appeal oversee the High Court of Sabah and Sarawak and are thus the final arbiter of legal issues. And since these appellate courts retain final authority, the decisions rendered by the state courts are ultimately reviewable by under the federal court structure. Now, a third issue relates to the special status granted to the states of Sabah and Sarawak, an integral part of their agreement to integrate into the Malaysian Federation in 1963 and its subsequent implementation in practice. So as noted, the 1963 Federation was joined by the Malayan Federation, Sabah, Sarawak, and at that time, Singapore. And as we pointed out, Article 1(2) of the Constitution provides that the states of the Federation, at that time, provided that states of the Federation shall be A, the states of Malaya, comprising the 11 states in Peninsular Malaysia, and B, the Borneo states of Sabah and Sarawak. In 1976, it's worth noting that Article 1(2) of the Malaysian Constitution was amended to list all 13 states of the Federation, including Sabah and Sarawak, into a single category. And some in Sabah and Sarawak have viewed this amendment as appearing to downgrade the East Malaysian states to equivalence with the other 11 states of Malaya, rather than having them separated into a separate category. And this has, in some quarters, led to a feeling that a perception that the spirit of the 1963 agreement has not been upheld, and the 1963 agreement and its subsequent implementation has at various points in the nation's history, including recently and in recent times, with the political context and influx as it is, like being a source of some tension, or as been the source of like some discussion in the public and political discourse. So let me end, as I say, with some tentative broader observations from this comparative practice for the Moroccan Initiative for the Autonomy of the Sahara region. with the caveat, of course, that I'm not an expert on the Moroccan initiative, but here are some broader observations I think we can take more generally. As a matter of constitutional design, I think the Malaysian federal system may on the one hand represent to some degree a model for the Moroccan proposals for the Sahara region's devolution of judicial powers, in the sense that such a model was thought to afford autonomy over judicial powers for the regional body. Still, if I have to emphasize one thing, it would be that constitutional design is one thing and constitutional practice is another. And the East Malaysian experience over the last 6 decades in practice provides some insights that might help inform the proposals for the devolution of judicial powers in the Sahara region. So here are 3 broad observations. First, the location of final judicial authority is, I think, crucial in determining the extent of autonomy exercised in practice by a judicial system. In designing a separate regional court system for the Sahara region, actual autonomy will depend on which institution is able to exercise final authority of judicial review. And as we have seen as set out under Article 23 of the proposal by the Moroccan Initiative, the Moroccan Supreme Court or the Constitutional Council will have the power to override decisions of the Sahara Regional High Court. So it's important to consider, I think, whether and to what extent the regional court in the Sahara region will be able to exercise autonomy in practice. And it's worth considering conferring the final say over some or all judicial matters to members of the High Regional Court in the Sahara region. A second observation relates to the legal and constitutional constraints on federal power intervening into autonomous regions. Article 23 of the Moroccan Initiative states that laws, regulations, and court rulings issued by bodies of the Sahara Autonomous Region shall be consistent with the region's autonomy statute and with the kingdom's constitution. As we have seen, the lessons from Malaysia suggest that it is of particular importance to note how regimes of exception, like the invocation of emergency powers, for example, or of extensive national security laws in other contexts, can sometimes be wielded in ways that might undermine even explicit protections for judicial power of an autonomous region, as illustrated by the 1966 episode we discussed earlier, where the federal government declared a state of emergency that in effect overruled the decision of the Sarawak High Court and allowed for amendments to the state and federal constitutions. I will note that it's encouraging that the Moroccan initiative contains some explicit textual safeguards against intrusion of federal power. Article 29 of the Autonomy Initiative provides that the Moroccan constitution will be amended and the autonomy statute incorporated into it to guarantee its sustainability and reflect its unique place in the country's national juridical architecture. And additionally, and importantly, Article 25 of the initiative indicates that the Sahara region's populations shall enjoy all the guarantees afforded by the Moroccan constitution in the area of human rights as they are universally recognized. And so it will be crucial, I think, for these textual provisions to be upheld in practice in order to function as effective safeguards. Third and finally, I conclude on a broader observation on the importance of constitutionalism in text and constitutionalism in practice. As comparative constitutional law scholars the world over have seen over the last few years, and it's particularly over the last few years, textual constitutional legal guarantees for any region or any constitution may play out in unanticipated ways over time. And even as we have seen from the East Malaysian experience, if the special status promised to an autonomous region is not given effect in practice, this might risk aggravating tensions between the territory and the federal government. So for any constitutional experiment to succeed, whether in East Malaysia, whether in the Sahara region or elsewhere in the world, good faith and continued efforts in practice will be required to maintain the agreed-on balance of powers between the federal and autonomous regions, whether in relation to legislative, executive, or judicial powers. A constitutional text can only go so far. Effective constitutionalism ultimately, I would argue, must stem from the ongoing practice of all institutional actors involved for the constitutional experiment in devolution to succeed. So I will end there. Thank you very much.
Thank you very much, Yvonne. This is a very impressive description of the East Malaysian system, which I must admit, is not so well known in the world. So thank you for making it more understandable and accessible to all of us. And thank you for your takeaways, which are very useful for the Moroccan initiative. I understand, unfortunately, you have to leave us, so you won't have a chance to be asked questions, but thank you for sharing your email. And if anyone is curious about your research, of course, they can write to you directly. And we look forward to publishing, of course, your fully fledged article. Thank you again so much. And now the interpreters are going to rest because we'll switch to French and maybe with a slower pace. So, je voudrais juste, I would like first to recall that you can switch the channel for the language. Under your screen, you have interpretation. You can choose English or French. And I will now switch to French. J'ai le plaisir d'accueillir Jean-Louis Roy, qui est un universitaire, journaliste et diplomate. Il a été directeur du quotidien Le Devoir, délégué général du Québec à Paris, secrétaire général de l'Agence intergouvernementale de la francophonie, président de Droit et démocratie, fondateur de l'Observatoire mondial des droits de l'homme. Il est titulaire d'un doctorat en histoire de l'Université McGill, d'une licence en histoire de l'Université Laval et d'une maîtrise en philosophie de l'Université de Montréal. Il a enseigné l'histoire contemporaine à l'Université McGill, à l'École nationale d'administration publique de Paris, au Collège universitaire Glendon, l'histoire sociale aux universités d'Ottawa et de Trois-Rivières, et la géopolitique à l'École polytechnique de Montréal. Il a également été chercheur invité au Centre de recherche en droit public de l'Université de Montréal. De nombreuses organisations internationales, dont le Haut Commissariat aux droits de l'homme, l'UNESCO, l'Organisation internationale de la francophonie, l'Organisation islamique pour l'éducation, la science et la culture, font appel à son expertise, ainsi que plusieurs gouvernements, y compris ceux du Québec et du Canada. Il a présidé le conseil d'administration du Centre de la francophonie des Amériques et depuis 2009, il est membre du conseil consultatif sur la responsabilité sociale des entreprises d'exportation et de développement Canada. Il est conseiller aussi d'entreprises du secteur privé. Il siège au Conseil des relations internationales de Montréal, au Conseil d'orientation stratégique de l'Agence universitaire de la francophonie, qui regroupe 800 universités, ainsi qu'au Conseil d'administration de l'Ordre national du Québec. Il est docteur honoris causa des universités de Moncton et de Sainte-Anne, et décoré par plus de 20 pays. Et il est l'auteur de nombreux ouvrages d'histoire, d'analyse politique et de création littéraire publiés en 6 langues, au Canada, aux États-Unis, au Brésil, en France, en Belgique, en Espagne, au Liban, au Maroc, au Sénégal et en Chine. Et jusqu'à récemment, il était président-directeur général de Bibliothèque et Archives nationales du Québec. Il va nous parler maintenant du système de dévolution des pouvoirs judiciaires au Canada. Jean-Louis, la parole est à vous.
La prochaine fois, Marc, il faudra simplifier parce que je suis surtout avec vous pour apprendre et j'ai beaucoup appris, notamment de ce qu'on vient de nous dire sur la Malaisie. Je trouvais qu'il y avait avec le Canada des ponts extraordinaires, notamment concernant les droits des Autochtones sur lesquels nous travaillons beaucoup au Canada et trop lentement en ce moment. Et je suis très, très intéressé par notre collègue et ce qu'elle nous a dit sur la Malaisie. Je voudrais saluer l'initiateur de notre rencontre, l'ambassadeur Omar Hilal, représentant du Royaume du Maroc aux Nations Unies, et signaler sa présidence remarquable à la première commission de la 76e session de l'Assemblée générale, la commission sur le désarmement et la sécurité internationale, qui est un des hauts lieux de la raison même d'exister des Nations Unies. Écoutez, je suis pas juriste, je suis un historien de formation, donc vous allez le sentir un peu dans la façon dont j'ai organisé cette réflexion sur non pas une comparaison, mais une analyse en parallèle convergent du système judiciaire du Canada et de cette formidable initiative. Je la suis depuis longtemps, je la soutiens depuis longtemps. Je le dis au début pour que ce soit clair pour tout le monde, c'est pas une analyse pour moi très objective, c'est un choix politique. Et je trouve que l'initiative marocaine sur une des questions très sensibles de guerre et de paix, de qualité de vie pour des communautés humaines plutôt fragiles, que l'initiative marocaine apporte une formidable réponse. Sur les deux mondes, le système judiciaire au Canada et l'initiative marocaine pour l'autonomie du Sahara, évidemment, on parle de deux histoires tout à fait singulières, mais l'analyse que j'en fais, c'est que si les histoires sont singulières, les principes sont convergents. Et c'est l'idée centrale de mon intervention aujourd'hui, c'est de montrer que sur les questions les plus fondamentales, au-delà de l'organisation, etc., mais qui en dépendent aussi, les deux systèmes que je vais comparer s'inspirent finalement de principes fondamentaux qui sont convergents. Deux systèmes donc très différents par leur durée dans le temps. Le système canadien est un jeune système, il a un siècle et demi seulement, ce n'est pas si long. L'initiative marocaine est encore beaucoup plus jeune, elle vient d'être prise en quelque sorte ces dernières années. Donc, il s'agit de deux histoires et je les compare, je les mets en parallèle au début en termes de temps, parce qu'il est évident que l'initiative marocaine va connaître dans les prochaines décennies, les 2, 3, 4, 5 prochaines décennies, des ajustements, des ajustements qui naîtront des pratiques constitutionnelles qui seront inaugurées, donc qui vont forcément évoluer. Il y aura des décisions constitutionnelles qui seront prises, qui préciseront des choses. En tout cas, c'est l'expérience canadienne. Nous vivons au Canada dans un système judiciaire qui a été établi en 1867 et il a été depuis très grand nombre de fois amendé par le Parlement de Londres, par la Constitution du Canada, notamment la Constitution, la nouvelle Constitution canadienne de 1982. On compte 30 modifications à la Constitution canadienne depuis 1867, et un grand nombre des modifications de la Constitution canadienne touchent le système judiciaire. Pourquoi ces modifications? D'abord, la pratique constitutionnelle, je viens de l'évoquer, qui précise un certain nombre de choses. Je dirais les besoins des parties en présence, les besoins dans le cas du Canada. Le Canada initial, c'est 4 provinces. Le Canada aujourd'hui, c'est 10 provinces et 3 territoires. Donc, dans un régime fédéral, la montée du nombre des États fédérés, entre 4 et 13 aujourd'hui, et il y en aura d'autres qui viendront compte tenu du développement de la région de l'Arctique, qui est 40% du territoire canadien. Donc, l'arrivée, je dirais, de nouveaux territoires, mais de nouvelles populations avec des distinctions très particulières. J'étais très intéressé par ce qu'on vient d'entendre en Malaisie sur le droit des Autochtones. C'est sûr que le développement vers l'Arctique du Canada va permettre aux populations qui vivent là depuis des siècles et des siècles de à la fois de s'insérer dans un système judiciaire plus vaste qui est celui de la Fédération canadienne, mais vont vouloir aussi que soient respectées les longues traditions, les longues pratiques concernant la justice, concernant les droits, concernant les droits individuels, concernant aussi les droits collectifs. Ces communautés ne sont pas des sommes d'individus, elles sont des nations, elles ont des histoires collectives qui se projettent parfois plutôt en millénaires qu'en siècles. Donc ce jeune pays qu'est le Canada est obligé d'insérer, obligé, c'est-à-dire se voit amené à insérer dans sa chronologie des fragments qui, eux, touchent des très très longues périodes de la vie de l'humanité. Donc on verra sans doute l'initiative marocaine pour l'autonomie du Sahara ajustée en fonction de choses que l'on peut prévoir maintenant et de choses qu'on ne peut pas prévoir. Je pense par exemple à tout ce qui viendra dans les prochaines décennies de l'obligation en termes des écosystèmes de protection de l'environnement. Je ne veux pas entrer dans trop de détails, mais je crois par exemple que pour les grandes villes du monde, certainement dans mon pays en tout cas, mais je vois ça plus largement dans le monde, l'autonomie des villes, la dévolution d'un grand nombre de pouvoirs vers les villes qui seront au premier titre chargées de répondre aux assauts en quelque sorte de la nature, vont modifier profondément le donné constitutionnel. Donc l'initiative marocaine pour l'autonomie, un peu, je la compare pas à l'expérience canadienne, je la mets en parallèle, comme j'ai dit précédemment. On est obligé de la penser aussi comme une donnée de départ absolument fondamentale, mais qui va sans doute et constamment évoluer. En tout cas, c'est l'expérience du Canada. Là où l'expérience marocaine est différente, très différente de la nôtre, mais on peut trouver des ponts aussi, c'est le fait que le système et les pratiques politiques du Canada, et notamment dans le cas de l'autonomie du système judiciaire canadien, est incompréhensible en dehors du système colonial britannique. Jusqu'à récemment voulant dire 1950, 1949, 1950, les appels au conseil judiciaire du conseil privé britannique en matière pénale constituaient les derniers appels possibles. La souveraineté du Canada sur son régime judiciaire a été, je dirais, une vraie bataille. Je le dis dans le texte qui vous sera remis, je fais l'inventaire des demandes à compter de la fin du 19e siècle. Ensuite, toutes les grandes démarches successives, il y en a une bonne dizaine pour gagner une part d'autonomie du système judiciaire canadien. Eh bien, il n'y a pas question de ça concernant le régime que nous étudions aujourd'hui. Le système marocain dans son ensemble est un système qui appartient aux Marocains totalement, complètement, et sa façon de le penser, sa façon par exemple dans le cas qui nous occupe aujourd'hui, sa façon de partager le pouvoir judiciaire entre le royaume et le Sahara, cette province pas tout à fait comme les autres, dont l'autonomie lui donne des prérogatives qui lui sont propres, ce partage-là est une donnée que les Marocains négocient entre eux. Dans le cas du Canada, c'était un très long travail qu'il a fallu faire. Je dis 1949 au dernier recours au conseil privé, mais à la vérité, c'est 1981-82. Vous savez que jusqu'en 1981-82, le Parlement du Canada ne pouvait pas modifier la Constitution du Canada. C'est le Parlement de Londres seul qui pouvait modifier la Constitution de la Fédération canadienne. Et ça a été une très longue histoire aussi que d'acquérir la pleine souveraineté sur le texte fondamental, le texte évidemment de base de la vie politique, de la vie judiciaire du pays. Il fallait attendre 1981 pour que le Parlement de Londres vote une loi qui permette de transfert donc de ce pouvoir de modifier la Constitution canadienne aux autorités canadiennes. Et ça a été l'occasion, 81-82, de revoir le partage des responsabilités, le partage des juridictions. En 81-82, le Canada donc devient, entre guillemets, pleinement souverain, même si la reine d'Angleterre est toujours le chef d'État du Canada, il reste ce symbole-là, mais la capacité donc du pays de modifier son régime politique, de modifier son régime juridique, lui appartient en propre désormais, et un examen qui va se faire en 81-82 et qui va conduire à l'adoption d'une loi constitutionnelle de 1982 où le partage des pouvoirs entre l'État central du Canada, les provinces canadiennes, les territoires canadiens, va faire l'objet d'une révision très profonde, puisque s'ajoute à la constitution du pays une charte des droits qui a autorité, peu importe les juridictions des uns et des autres, sur l'ensemble du territoire, sur la totalité des juridictions, la juridiction fédérale, la juridiction des provinces, les juridictions aussi des grandes villes, des municipalités du Canada. La loi constitutionnelle de 81-82, je signale aussi en passant qu'elle suit un premier référendum sur l'autonomie du Québec. On parlait plus de la souveraineté du Québec que de l'autonomie du Québec. Référendum qui a eu lieu en 81 et qui ne donne pas de résultat favorable à l'autonomie du Québec, à la souveraineté du Québec, mais c'est quand même une donnée politique exceptionnelle, puisque si je parle de la révision de la Constitution de 81-82, elle se fait dans un contexte où un des États fédérés fondateurs, le Québec, qui est aussi un État culturellement distinct du reste du Canada, linguistiquement distinct du reste du Canada, et on pourrait dire socialement distinct du reste du Canada, a organisé quand même un référendum sur la souveraineté, référendum qui sera repris en 1995 et qui va être à nouveau négatif pour ceux qui soutenaient la thèse de la souveraineté, mais à moins d'un point de différence entre ceux qui favorisaient la pleine souveraineté du Québec, la séparation donc du Québec du Canada et le maintien du Québec dans la Constitution canadienne. Ces facteurs politiques ont un effet constitutionnel considérable, ou immédiatement parce qu'on fait des ajustements. En 81, le premier ministre du Canada du temps, M. Trudeau, le père, avait promis des changements constitutionnels significatifs. Il l'a fait parce qu'il y avait eu, évidemment, ce référendum. Je reviens au système judiciaire canadien. Je dirais que c'est un système intégré. Il n'y a pas de dévolution comme telle. C'est un système complexe. Il est complexe parce qu'il intègre le common law et le droit civil. C'est déjà une première complexité. Il repose sur un partage des pouvoirs judiciaires entre l'État fédéral et les États provinciaux, les territoires, parce que en ce moment, au moment où nous nous parlons, il est en train de s'interroger très substantiellement sur l'intégration du droit des Premières Nations, du droit des Autochtones. Est-ce qu'on ira vers des tribunaux comme la Malaisie? On vient d'entendre que la Malaisie a des tribunaux, que les Autochtones malais, il y a des tribunaux qui leur appartiennent en propre, à partir de leurs propres traditions, etc. Il y a cette pensée au Canada en ce moment. Ou est-ce qu'on intégrera dans les cours de dernière instance du système judiciaire des provinces et de l'État fédéral des représentants des communautés autochtones qui siégeraient en apportant la contribution de leur tradition juridique, etc. Il y a tout un grand débat au Canada en ce moment sur ces questions très complexes, très difficiles et très douloureuses aussi d'une certaine manière. Et quand je disais tantôt le système que propose le Maroc pour cette province particulière va évoluer, eh ben c'est ce genre de questions tout à coup, des groupes, des situations qui étaient jugées, comment dire, qui étaient jugées correctement intégrées dans le système s'avèrent tout à coup autrement. Et on doit donc revoir au fond, dans le cas du Canada, revoir au fond la relation qu'on a avec une petite proportion, 4%, les Autochtones au Canada sont 4% de la population, mais c'est un 4% qui compte, compte tenu de leur place dans l'histoire, etc. Alors, le système judiciaire canadien, je viens de le dire, il y a des cours fédérales, il y a une cour, le gouvernement fédéral a l'obligation de créer, de maintenir, d'organiser une cour générale d'appel au Canada et des tribunaux additionnels pour l'administration des lois, etc. Il y a une cour suprême. La Cour suprême du Canada est une cour fédérale dans laquelle il y a 3 juges du Québec c'est dans la Constitution, les 9 juges de la Cour fédérale représentent l'ensemble du territoire, évidemment, sont nommés par le Premier ministre du Canada, après consultation avec les provinces. Dans le cas du Québec, compte tenu que le Québec a un système judiciaire différent et applique le droit civil plutôt que la common law, eh bien, il y a 3 juges de cette tradition juridique qui se retrouvent à la Cour fédérale du Canada. À la Cour suprême, pardon, du Canada. Les décisions de la Cour suprême sont sans appel et sont d'application immédiate, peu importe que les jugements qu'elles portent découlent d'une contestation d'une loi fédérale ou d'une contestation d'une loi des provinces ou des territoires. C'est une cour de dernière instance pour toutes les cours du pays. Cette position de la Cour suprême du Canada assure à l'ensemble de la pyramide judiciaire, les cours fédérales, les cours provinciales et le droit civil et la common law, assure à cet ensemble un peu disparate quand même, plus le droit des Autochtones que j'ai mentionné précédemment, l'ensemble des décisions de la Cour suprême finit par créer une jurisprudence commune forcément, puisque leurs décisions sont d'application sur tout le territoire. Et en dernière instance de toutes les cours de justice, l'unité du système judiciaire canadien provient très largement des décisions de la Cour suprême. J'ai eu l'impression, mais je ne veux pas m'avancer trop, en lisant le texte de l'initiative marocaine, que certaines références qui sont faites à la tradition, laissez-moi trouver exactement ce que je vais vous dire, certaines références qui sont faites je veux avoir les termes exacts, donnez-moi une seconde. Voilà, les décisions sont rendues au nom du roi. Cette référence implique une connaissance et une reconnaissance de la jurisprudence découlant de cette haute exigence. Deuxièmement, il y a devoir de conformité entre les décisions de justice émanant des organes de la région autonome du Sahara et le statut d'autonomie de la région et la constitution du royaume. On ne peut pas s'écarter, et ça ne peut pas être autrement non plus, les compétences de la Cour suprême. Il doit y avoir conformité entre les décisions de justice prises par les organes de la région autonome du Sahara et la constitution du royaume. C'est un peu, je ne fais pas un parallèle absolu entre ce que nous vivons au Canada et ce qui est proposé ici, mais je dirais que c'est finalement les mêmes valeurs. Il ne peut pas y avoir à l'intérieur d'un même pays, sur les questions les plus fondamentales, il peut y avoir des ajustements, il peut y avoir des accommodements par rapport aux régions, par rapport au statut des uns et des autres, mais il peut pas y avoir sur les fondements des décisions de justice et l'application notamment des droits des personnes, des divergences, comment dire, essentielles. Enfin, troisièmement, les compétences de la Cour suprême et du Conseil constitutionnel du Maroc sont affirmées comme instance de dernière instance, comme l'est la Cour suprême du Canada. Donc, je crois qu'il y a une vraie marge d'autonomie pour les instances judiciaires de la province du Sahara. Cependant, cette marge d'autonomie, qui est réelle, se fait dans un contexte où cette province appartient à un ensemble plus vaste, un ensemble plus grand, qui est le royaume, qui a déjà sa jurisprudence, qui a déjà son autorité, je dirais, constitutionnelle suprême, qui est le roi. Ensuite, évidemment, la Cour suprême et le Conseil constitutionnel du royaume. Il m'a semblé que le caractère souverain du régime judiciaire marocain est assuré. Il m'a semblé qu'il y avait des éléments d'un partage des pouvoirs judiciaires assez clair, un peu comme pour le Canada, dans les institutions proposées pour la province du Sahara. Il m'a semblé aussi que l'unité quand même du système judiciaire du pays était garantie par ce que je viens d'évoquer. Et on peut même imaginer, on a vu ça, j'imagine que ça doit être la même chose peut-être au Cameroun, que les décisions des cours de justice du niveau des provinces peuvent avoir un impact aussi. Il n'y a pas simplement la Cour suprême qui a un impact sur l'ensemble de la jurisprudence, mais que les cours de justice du niveau provincial, pour certains des jugements qui sont portés, peuvent influencer la Cour suprême. La Cour suprême peut s'en inspirer et elle s'en inspire. Il y a un va-et-vient, je dirais, assez, comme dirait un philosophe français, il y a de l'évolution créatrice entre la Cour suprême qui inspire les tribunaux qui n'ont pas le choix. La jurisprudence de la Cour suprême est impérative, mais la Cour suprême n'est pas indifférente, loin de là, aux décisions des tribunaux sur lesquelles elle doit se prononcer. La Cour suprême, ses matériaux sont les décisions des autres cours de justice, de tous les niveaux. Donc, elle tire des cours fédérales sûrement, mais aussi des cours provinciales. Elle tire de cet ensemble de travaux, un ensemble de réflexions, un ensemble de décisions des cours de justice de tous les niveaux, des matériaux qui lui sont très utiles pour sa propre réflexion et pour ses propres décisions. Voilà ce que m'ont inspiré la lecture de la Constitution du Canada et du texte concernant l'initiative marocaine. Unité du système. Le système va évoluer, je l'ai mentionné précédemment. Il m'a semblé, je reviens au début de mon propos, que voilà des histoires très singulières. Et si j'ajoute au Canada, qui y arrive très tard, mais qui finit par y arriver, la tradition juridique des Autochtones, ce sont des histoires vraiment singulières. Celle du Maroc et du Sahara et celle du Canada. Mais il m'a semblé qu'il y avait dans les deux cas des principes de base, des principes fondamentaux convergents. Je vous remercie.
Un grand merci, Jean-Louis, pour ce panorama à la fois historique et juridique et comparatif. Donc, il montre bien à la fois les spécificités de chaque système, compte tenu de son histoire propre, mais aussi les convergences possibles, et les leçons, les enseignements que l'on peut tirer, qui peuvent bénéficier aux initiatives les plus récentes, comme celle du Maroc. I will now switch back to English to maybe have a short opportunity to discuss or to ask questions. If anyone among the participants wish to ask questions, they can do so in the Q&A button down their screen. And of course, the remaining speakers are also free to interact with each other, maybe comment on each other's presentations. So if you have any question or comment, this is the short opportunity that you will get. And that it seems that everything has been very clear from every speaker, so it doesn't require more enlightenment. And as I said previously, of course, the full-fledged articles will be published shortly, so you have a chance to read these articles. They will be published in print and disseminated by the Moroccan Permanent Mission, but they'll be also available on the website of the Academic Network on Autonomy website. So, of course, we will share this link and the availability of the proceedings of this seminar as soon as they are available. And also because we've been recorded live on YouTube, the recording, the video of the seminar will be also accessible to everyone interested. The link is already made available by Majda in the chat, so you can copy this link, and I'm sure if you haven't had a chance, this will be available throughout other channels and frameworks. So if there is no question, I will just try to conclude or to identify some possible takeaways. Of course, I will not repeat the contents of the various presentations, but I think we had an interesting focus throughout these presentations on the origins of the existing systems of devolution of judicial powers, which are, of course, are very much related to the historical developments. In Europe, of course, we have seen these affected by the wars, the conflict, the changes in political systems over the centuries, and they are still, of course, very much influenced today by this historical heritage. In other cases, I would say the main heritage can be described as colonial, of course, under various forms. Again, this is something in common that we can identify with the Moroccan initiative. Of course, Morocco used to be a French colony, and the dispute over Western Sahara, of course, was the result of the withdrawal from Spain, and therefore, since then, this conflict has been protracted, and that's why the initiative to solve it through the autonomy project has been so important. So, in common, we can see very much this influence of history and the colonial heritage. As mentioned by Joan Joseph, actually, devolution of judicial powers in the world is a fairly rare phenomenon, including in cases of advanced autonomy or even federalism. This is confirmed by his composite indicator, which helped to compare judicial decentralization in countries of Western Europe, but also with the Moroccan initiative. So we can see that maybe a large devolution of executive or legislative powers, but still some fairly centralized judicial systems. And again, this indicator is very precious because it's based on objective criteria which we can measure, and that's where this system of rating the various systems based on these criteria is so important, both for self-rule and shared rule. Again, as we have seen in the case of Cameroon, the colonial heritage is very much present still today, because like in Canada, we have this opposition or this juxtaposition of two legal systems, the common law system and civil law system inherited either from the British or the French former colonial powers. Now, in Morocco, we don't have this problem because we have a unified state with a unified legal system, and that's an advantage. So the judicial autonomy can be based on the same legal system, but still exercise this autonomy. And also, we have seen that when in Cameroon it was changed, the system was changed from federalism to a unitarian state. Of course, this actually didn't help solve the conflict, which actually resulted from the domination of one legal system over another, and the linguistic interpretation, the linguistic translation of this system, of course, is also remains part of this conflict, which is still very active today. Of course, in Morocco, we don't have the same problem because the language differences are not so fundamental, and they're more cultural. Of course, according to the initiative, any regional language or culture, the Hassani culture, will be fully respected and fully autonomous. But that doesn't change the fact that the whole Moroccan population speaks the official language, Arabic. Now, this notion of conflict, of course, is still also part of the determining factors that sometimes still influence the search for solutions, resolution of the conflict through autonomy. And it's important, as was pointed out by Laura, that we have a system of autonomy which is the result of consultations or negotiations among all the parties and not imposed from the top, because as we have seen, it just is not working. And the fact that in the case of Cameroon, there is no actual devolution of judicial powers is not helpful to solve the conflict. And that's why it was so important for the Moroccan initiative to include this aspect and not limit the devolution of powers to executive or legislative powers. Now, as we have seen in the case of East Malaysia, again, the colonial heritage is still present. And the result is a sort of semi-autonomous system with autonomy on design of the court system, judicial appointments, and the legal profession, and a sort of mix of independent and concurrent powers with the federal judicial powers within some territorial limits. And this is where, again, there is some comparison with the Moroccan initiative, which delineates the jurisdiction of the autonomous region within its territorial limits and provides for a form of concurrent exercise of judicial powers with the kingdom. It also includes, of course, provisions on the recruitment and the exercise of power. And as was pointed out by Yvonne, it's very important also to keep in mind the distinction between the legal provisions, the constitutional provisions, or the design of the system, and their actual implementation and practice. So this is something, obviously, that will be important to keep in mind. Similar to Malaysia, of course, there is this idea, and like also in Canada, there is the idea that there is a supreme judicial power exercised across the whole country, and this is the case also in Morocco for Sahara. But this also requires some safeguards against any abuse by the central power, the federal power, to encroach upon the judicial autonomy. And to finish with Canada, of course, again, reference to the colonial heritage, the historical experience and development, and also this is a lesson that Moroccan learned, that over the years, the system, even if it looks perfect on paper, can also be developed, adapted to new conditions. What's interesting that even in the case of a federal system like Canada, you still have some political, some constitutional powers for the former colonial power, the British Crown, but it is compatible with full judicial independence. Of course, this colonial aspect is not present in the Moroccan system, and as was pointed out by Jean-Louis, the sharing of powers, executive, legislative, and judicial powers done within Morocco with the Sahara region is not among Moroccans and not with a former colonial power. And also, as pointed out by Jean-Louis, the political factors can have constitutional effect, as was seen in the case of Quebec. and can generate a complex system, which can reconcile different legal systems like common law and civil law, territorial division of power, and also this notion that it is an evolutive system which now can move towards more devolution to a local, to a lower level, to integrate more rights for the First Nations or more autonomous populations. And finally, again, the unifying role of the Supreme Court to unify the doctrine, the cohesion of the legal, political, social requirements, to promote this balance of interest between the national interest, national prerogatives, and the regional, the local interest, which can be granted as full an autonomy as possible. So these are my personal takeaways. Again, we still have a few minutes if you have any chance to react.
I want to say a few words.
Yes, Ambassador, how are you? Please, you're welcome.
Cher ami professeur Marc Finot, cher professeur et académicien, je n'ai pas l'habitude d'intervenir dans les séminaires qui sont organisés par Marc Finot autour de l'initiative marocaine d'autonomie, mais cette fois-ci, je voudrais m'acquitter d'un agréable devoir, celui de vous remercier, rendre hommage à vos recherches, vous dire que j'ai suivi avec beaucoup d'attention et d'intérêt les présentations que vous avez faites. Comme l'a dit le professeur Jean-Louis Roy, ce n'est pas une analyse comparative, mais c'est une analyse parallèle, mais convergente. J'ai beaucoup aimé, cher professeur et cher ami, je suis très heureux de revoir, j'ai beaucoup aimé cette formule. La justice et les pouvoirs judiciaires, ou plutôt la justice en général, dans sa perception globale, elle est la base de tout vivre ensemble ou vivre en commun. Elle est la base de la démocratie. Elle est la base de la bonne gouvernance. La justice également, elle est la base d'une économie prospère. Elle est la base également pour le drainage des investissements étrangers. Elle est la base pour la réconciliation nationale. Comme on dit, la justice transitionnelle, c'est une étape vers la justice noble, globale, qui est basée sur le respect de tous les droits de l'homme et la loi de la Constitution. Pour nous, avoir une dévolution des pouvoirs judiciaires au sein du Sahara marocain dans le cadre de l'exercice, la mise en œuvre de l'autonomie est un des piliers fondamentaux. D'ailleurs, c'est un des piliers de l'autonomie à côté du pilier exécutif, le pilier législatif, le pilier économique et le pilier judiciaire. C'est pour ça que nous avions besoin d'entendre les échos sur les autres expériences, sur les autres pratiques. Et dans cet exercice, dans lequel nous avons abordé tous les aspects, toutes les facettes et les composantes du projet marocain d'initiative d'autonomie, nous avons toujours cherché la convergence. Nous avons toujours cherché là où il y a le décalage pour un petit peu nous rapprocher. Et avec un seul objectif, avoir, lors des négociations, une initiative évolutive, ouverte à la négociation. Le fait que nous puissions, depuis 10 ans, discuter chaque année d'une thématique, c'est le gage de notre engagement lorsque nous disons ce n'est pas à prendre à laisser, mais c'est à négocier. Nous sommes prêts Dites-nous qu'est-ce qui ne marche pas, dites-nous qu'est-ce qu'on pourrait arranger, dites-nous où on pourrait enrichir ensemble lors de la négociation, lors du processus politique. Et en écoutant professeur Juan José Valipe sur Catalogne, en écoutant également le professeur Laura Stella Inonchang sur le système judiciaire camerounais, fédéral camerounais, ou bien le professeur Yvon Thiou sur le système Sabah et Sarawak en Malaisie orientale, ou bien le système québécois que le professeur Jean-Louis Roy vient de présenter avec beaucoup de clarté, beaucoup de détails. Eh bien, nous, on veut prendre ce que vous avez de meilleur. Nous n'avons jamais prétendu que notre texte il est bien, mais nous voulons l'enrichir, comme je l'ai dit, l'améliorer et en faire quelque chose qui puisse honorer notre attachement à la justice, à la paix, à la réconciliation et surtout à une solution politique. Parce que du moment que nous disons l'autonomie devra être la solution, la seule solution qui puisse permettre le règlement définitif, durable de ce conflit régional, ce différend régional, ben nous voulons que cette justice et la dévolution des pouvoirs judiciaires soient les meilleurs, qu'ils puissent s'inspirer des meilleurs exemples dans le monde et qu'ils puissent être également la garante de la vie quotidienne de chaque citoyen au Sahara marocain. C'est des observations que je tenais à faire avec vous en vous renouvelant mes vifs remerciements, notre profonde gratitude, en vous disant, comme d'ailleurs l'a dit le professeur Marc Finot, vos présentations seront publiées immédiatement sur le site web qui est dédié exclusivement à tous les aspects de l'autonomie, pas seulement au Maroc, mais également dans le monde. N'importe quelle recherche peut être intégrée. Et également, nous, comme nous l'avons fait pour les précédents séminaires, nous allons le publier dans un petit livre en français, en anglais, et vous recevrez des copies de cette impression, de cette publication. Encore une fois, mille merci, très heureux de travailler avec vous et j'espère très prochainement vous recevoir au Sahara marocain pour que vous puissiez voir en quelque sorte le bourgeonnement de vos idées, de vos propositions et surtout le parallèle entre ce que vous avez chez vous et ce que nous avons pris de vous pour mettre chez nous et offrir la justice la plus juste, la plus équitable à nos citoyens au Sahara marocain. Merci, cher professeur Marc Finot, merci, cher académicien Yann.
Merci, monsieur l'ambassadeur. Et je crois qu'il n'y a pas de meilleure conclusion pour notre séminaire. Donc, c'est mon tour de remercier les participants, les conférenciers, et à vous souhaiter un bon été et espérons nous retrouver prochainement autour d'une nouvelle thématique sur l'autonomie. Merci encore. À bientôt.
Au revoir.